Yes, Mr. Das.
Item number 4.5 methods, the hearing method. Can it be assumed for I've
These
taken
are
the concern to the other side method.
15 matters.
Evidence part is not with me. I'm trying to collect.
15 matter difficult, Mr. Das.
It should be performance of contract matter.
15 matter, we don't adjourn for this non-collection of evidence. Somebody is ill seriously, then the matter is different. 1 day's accommodation, 2 days accommodation. Difficult. Okay, Tuesday. Tuesday next. 3 and thus, Learned Counsel for the appellant has made a prayer for adjournment. Full stop. Considering considering that the appeal is of the year 2015, while the said prayer is declined, comma, a short accommodation is granted, directing listing of this matter on Tuesday next.
Well, I've taken the concern of the other side method.
Okay, Tuesday next. Tuesday khula ase to?
May plot. But the back to consider item number 12 plot. So
You're appearing in person? Are you appearing in person?
Yes, sir. But the my senior is a learned senior counsel team within the lordship. Yeah, personal difficulties. But the matter of the admin already taken the concern of the other part.
No, who is the petitioner?
Petitioner is my elder brother, Lord.
You cannot appear like this. Are you a petitioner?
As per the instruction from my senior.
Are you a petitioner?
You
You are the counsel.
Yes, Lordship.
Where is your uniform?
First, the last question is this query, Lordship. So I was appear.
Where is the uniform? If you appear in person, no problem. You are not the petitioner.
So that's a lot. The previous occasion, Lordship, there is this query, Lordship. So that's why I did not wear my gown, Lord.
You have to wear the gown. You can appear as a counsel in a representative capacity. And the petitioner is welcome to address directly. If you are the petitioner, you can come. But
Yes,
you are the counsel.
Yes, Lord. I'm sorry for that. My senior will. My senior will. I'm sorry.
Yeah, because with the concept of response, I think the
10 years.
that's it.
Use the microphone, please.
This matter is said by
Yes. 18 matter. Okay. Next Thursday. Okay. A prayer for adjournment has been made on behalf of Sri K. N. Chaudhary, London Senior Counsel for the appellant list. List on 20 over 26. Yes. Which item, madam?
Lordship, it's regarding item number 12.
12, yes. What is it? What is your prayer?
Lordship, this needs some
Time. It's for hearing. When do you have? Thursday next. Thursday next. Okay. Okay, Thursday, huh? On behalf of the appellant, appellant petitioner. Thursday, okay. Yes,
It is
madam.
the Lordship. Lordship, I beg to mention for listing of an IA, Lordship. IA in CRP number 65. This CRP has been listed tomorrow before your Lordship as item number.
Okay.
This IM attached.
Have you filed the IA?
It is
Being filed.
Main file has been filed.
It is being filed. Have you filed or being filed?
Being filing on the filing.
Okay, ensure it, the filing will have it,
Yes.
no problem.
Yes.
Okay.
Yes, your Lord. Regarding supplementary 26-day matter, we have for the sole respondent who have filed our affidavit today. Requisition may be allowed.
Yes, yes, bring it.
Lordship, I beg to mention for this thing. I civil matter.
IA for?
I civil 534
For what?
CRP.
IA is for what?
Urgency for stay of execution.
IA is for stay.
Stay.
When did you file?
16/2/2002.
16 to?
2024.
Has it has not been listed?
No.
Okay, we'll have it Wednesday next. Okay.
May is my lordship, I beg to mention item number 7 and 8 of today's date.
Yes.
I am appearing on behalf of Mr. M.K. Borua.
Hmm.
So lordship, he is appearing before Kohima Bank, so he has certain difficulty today. So this matter kindly be taken up on
27th of
27th of June, is it possible to for a hearing?
Thursday.
Thursday, what is the week? It is the last week of before the vacation. All the days will be declared motion. And these are all matters, madam. Yes, tell us. Well, it's a old matter. We don't want to adjourn like this. It'll go after the vacation. We don't want to adjourn till the vacation.
Lordship, can it be taken up on 20th this
We'll try on 28, 20.
20th
Okay, okay.
oblige?
Item number 7, huh? You're for the, madam, you're for the
7 and 8, lordship.
7 and 8, we are for the appellate.
appellant. Okay.
I think 7 and 8.
8, you are the, it's a cross objection.
Yes.
Okay.
Lordship, let both the appeals
Okay,
come
Miss
together.
P. Doctor, learned counsel for the appellant has made a prayer for a short accommodation. Full stop. Your Edeka,
Yes.
Sri Edeka learned counsel for the opposite party, who is also the cross objector in the connected cross objection, is present. Full stop para as agreed. List this matter on 20.
Lordship,
20.
both the matters may come together.
Okay.
Yeah, these are listed together itself. 7 and 8. Okay.
Snap it. I recommend for listing of
I for
order. I for
what orders?
it was not for delay petition. It was issued notice in 2023. After that,
I is for condemnation of delay.
yes, not been
Notice
listed
has
after
been
20.
issued.
Yes.
When was notice issued?
It was 22/9/2023.
Okay, we'll have it next week.
Okay.
Next Wednesday.
With regard to item 4, 5, my lord, I
Yes.
informed the others. Kiro Sudori will not be available. Can it be on Monday, my lord?
Monday is a holiday.
Yes, my lord, that is.
Wednesday. 19th.
Wednesday, Thursday.
Thursday we have already fixed. Okay, Thursday kore diya, 20 तारीख.
May I pray for listing of an MSc appeal for order
MSc appeal, you are who?
of 22.
You are what is
Appeal.
in the appeal? You are for whom?
Appellant.
Appellant, you are for enhancement. Enhancement. Appeal of which year?
22.
22. The insurance company has appeared. Cannot be possible. 22 matter. Have you seen the matters of 16, 17,
Yes, yes,
15?
madam. Orders only, I will fix a date for hearing after petition.
Okay, have it on Friday next.
My lord.
Friday next.
Friday.
Okay, please, your lord. My lord, I beg to mention item number 14. My lord may take it
1-4.
one. My lord may take it after vacation. We
New
have
matter.
taken-
Okay.
That I am appealing for the respondent. Can it be taken up on 23rd or 30th July?
July.
July.
Why we are going so late? We'll have it on 17th of July.
Right.
17th of July.
Yes.
Prayer for adjournment has been made on behalf of the petitioner. Sri Edhar, learned counsel, is present for the respondent. Full stop. List on 17/7, Wednesday.
Apply.
My lord, in the IA, there is an injury. Maybe
Interim order, if any, stands extended till the next date of listing.
oblige.
Okay.
I want to apologize. Lordship.
No, doesn't matter.
Lordship, as per the instruction from my senior lordship.
Doesn't matter.
Lordship,
That matter is over. We have forgotten.
Lordship, taken the matter after packaging lordship, as per the instruction.
We have said,
After packaging lordship.
I,
The consent of the other
he
party.
did this. 26th of?
Item number 12.
Bis 26. Let it be there. It's a whole matter.
Interim order passed. Continue.
There is an interim order.
Yes, Lord.
Item number,
12, Lord.
interim order in CRP.
Yes, Lord.
Hello, interim order, if any, stands extended till the next date of listing.
Passed. Obliged.
Mr. Mondal, you are for 1 and 2?
One.
Okay.
Then 15, something is for withdrawal.
Yes.
Lordship, kindly allow us to withdraw.
You are for whom? What is your name? RSA withdrawal, why?
Lordship, we have served notice to our client, but Lordship, as per instruction of our client.
What is your name?
Jai Hatimuria.
Sri J. Hatimuria Learned Counsel submits that there are instructions to withdraw this appeal. Full stop. Anyone appearing for the other side?
For respondent number 1 and 4.
1, 2, 4.
1 and 4.
Not 1, 2, 4. Why? Huh? No, it was listed 1 and yes. Huh? Hit to some? Mr. Abhay, you are 1, 2, 4, not 1 and 4. Why don't you check your records? What is your name?
Zero.
Sri Rama Learned Counsel for respondent numbers 1, 2, 4 is present. Para? Appeal is dismissed on withdrawal.
Obliged.
One, top of the list.
May I please tell?
Hmm.
My lord, here in this case, I am the defendant number 5 in the suit.
Appellant is the defendant number 5.
5.
Suit for?
Suit for, my lord, it is decree declaring that plaintiff obtained decree of title suit number 15 of 79 for the suit land and has acquired right title interest over the same. That means the
There was an earlier decree.
earlier decree that was not put under execution, then again file a suit that that suit decree is binding. Now another
Suit
prayer
for declaration,
declaring that
declaration that
plaintiff
previous decree
obtained a decree
obtained by the plaintiff. Obtained by the plaintiff should be what?
acquired right title interest. On the basis of that decree, he acquired right title interest. Basic prayer is that on the basis of earlier decree, plaintiff acquired right title interest.
That decree was not put to execution.
Not put it. Then another interesting prayer, my lord. The suit be decreed declaring that defendants are legally bound abide by the decision of decree of title suit number so and so. Almost same prayer. Now permanent injunction can be granted restraining the defendant number 1 to 4. 1 to 4 is the state. From evicting the plaintiff from the suit land and give possession to the defendant number 5 for the same. I am the defendant number 5. Allotment has been given in favor of me. That was not put under challenge. Without putting under challenge, they sought declaration, injunction that I should not be put into possession over the land by the defendant number 1 to 4. This is the three pair. Three relief.
Okay.
And this decree which has been obtained in earlier suit, exactly same property, same land, all are same. There also declaration has already been given in favor of the plaintiff. And there was another order for correction of land record in favor of the plaintiff. And that decree was never put under execution. Without putting execution, they filed this suit. That too after lapse of more than 12 years.
Obviously, the limitation for the execution of the decree was over.
Was over. And another aspect that the land which has been allotted to me, that means to the cooperative society, Goripur cooperative, consumer cooperative store. That part of the suit property, on the basis of which we are allotted, we have constructed, there was a specific go down, all these things are there. They never challenged the allotment letter issued in favor of the Goripur cooperative, that is in favor of the applicant.
Both the courts have held against you.
Yes. And interestingly, the plaintiff is also in possession in their land. They are also in possession.
Their land.
Their land. We are also possession with respect to the
Suit
allotted land.
Okay.
Not suit land, allotted land.
Okay.
There are more than the suit has been filed for 2 kathas of land. There are more than 2 kathas of land.
You are not in possession of the land which is
No,
the
no.
subject matter of suit land.
No, and with clear specific boundary wall also there.
Yes, what do you say, Mr. Laskar?
And
We'll come back to you, Mr. Ghosh.
There is a decree, my lord, in favor of the plaintiff, my lord. The earlier decree, the suit was rejected, my lord, dismissed. And on April 1, it was decreed, my lord. And in the year 1991, my lord, it was decreed, my lord. And 1992, there is a 2 katha of land has been.
No, on the aspect, we are not hearing you on the
Okay.
merits.
Okay.
We are hearing you on the aspect of possession. He says that you are also in possession of the suit land.
Here is a dispute, my lord. Only the vacant land, the suit land is 2 katha, my lord. And remaining land is 3 katha. But the circle officer, my lord, going to demarcation, my lord, 3 katha of land, my lord, in favor of the defendant, my lord. If the demarcation is made, my lord, in favor of the defendant, my lord, 3 katha of land. But our land will, we are possessing our land in 2 katha, my lord. But they are possessing their land 1 katha, my lord. But the order is for 3 katha. That is why, my lord.
Which order?
Yes, order, my lord.
But that is not the subject matter of challenge.
Lordship.
Is that the subject matter of
Lordship,
challenge?
that's the injunction that was one. This was filed after this order passed by the ASO. This
The order of the ASO, is it the subject matter of challenge?
Lordship.
it is not challenge. I have read out the prayer.
Let us see the prayer in the plaint.
I have read out.
Mr. Laskar, show us the prayer that you are aggrieved by the order of the ASO, or you have made any averments.
Page 10 and
Yes.
page 10. Ticket, sir. Go through the ticket, page 18, 19, 19, page 19. Sir.
It's done with the One page missing.
No, no.
So page 8, my lord.
Is it there?
The plaintiff therefore prays that a suit be decreed declaring the plaintiff obtain a decree in title suit number 1579 plus title appeal 9379 for the suit plan and has acquired right title interest over the same. The suit be decreed declaring that the defendant are legally bound to abide by the decision of the decree in title suit number 15.
Same prayer.
Lord.
1 and 2 same.
A permanent injunction shall be granted restraining the defendant number 1 to 4, my lord.
Yes.
That's complaint.
For
From evicting the plaintiff from the suit land and give possession to the defendant number 5 for the
that
same.
is not enough.
That is
There has to be a specific challenge to the order of the SO. Then only it can be adjudicated. That is not even your prayer. The suit was decreed on what consideration?
On the consideration that there was an earlier decree. That is also not permissible under section 34 of this specifically.
Several thousand violated is figured by-
And substantial question of law was also framed on 7/12/2016, whether on the face of the prayer made by the plaintiff respondent, the judgment and decree passed by the court below are maintainable. This type of prayer is also not maintainable, my lord.
And there is the bar by the second point for declaration. By
Which order?
Page 7/12/2016. Order 7/12. Let me put it.
What will the principles of res judicata will not come in?
Yeah.
How do you overcome the aspect of res judicata?
Res
It was now you have not gone for execution. Can you again go for an adjudication or enforcing a decree by another
By
suit,
another
suit? Is it permissible?
and as per section 151, my lord, this was there is a bar, my
Section 151.
54. My.
Let us see.
There is judgment matter. Some land and
Oh, he's saying about Assam land regulation.
We are on strictly on the in examining the suit filed by you. We are not under the bar under the some random regulation, civil suit bar.
and there is also
What relief can be granted? Is it possible? We are not on the maintainability. We are on the ground that whether anything can be done. Filing a suit, okay, there is no legal bar. But what have you filed for? For enforcing a decree, which you have never executed. And you have not put to challenge the order of the settlement officer.
That order, they are purposefully have not challenged, because if that order is made, then it will be barred under section 154.
154, yes.
That is why they have not put under challenge. And he is saying that it is not barred under.
Did you approach the Board of Revenue also? No.
yes,
No.
my lord.
You had approached.
Yeah.
What had happened there?
Board of authority, I have not approached.
then.
Before
Not
the
rep-
board of
You
authority,
should
I
have taken the proper route, go to the board, come in a writ petition.
well approached my lord before the SCSO and
Thereafter,
1992, my lord.
thereafter, what had happened? You could
Nothing,
not
my
have filed a suit.
Nothing. That is why it was filed with my.
No, what prevented you from executing? And we are not even on the question of what prevented you. Why didn't you file an execution? You cannot file another suit for executing a decree. Yes, anything you're relying upon, Mr. Kos?
I am only with respect to that section 34 of this specific.
Let us see.
This suit is not.
Specific-
And regarding res judicata, my lord, earlier, actually it is in earlier suit, my lord, we are not the part. State was the part.
You are referring to which section?
Section part.
Before. Please read.
My lord, regarding provided that no court shall make any such declaration where the plaintiff being able to seek further relief, then a mere declaration of title omits to do so. Here they are claiming only declaration that earlier decree is binding, earlier decree is.
No, no, how is this proviso applicable to you?
Proviso, they are only seeking a declaration that earlier decree is on the basis of earlier decree, they acquired right title in them.
No consequential.
Though the prayer which has been made, the consequential regarding injunction
Yes.
part, in that part, my lord, because in earlier suit, defendant number 5 was not the party. State of Assam was the party. And in that suit, earlier suit, their specific prayer was for correction of land record. It was a first land. Originally, this land is a first land. They are possessing that land. So they sought for declaration and for correction of land record.
Where is the, what is the order date of the ASO? Is it a part of the record?
Page 8, can you see, my lord?
Of?
Page 8 of the plaint. The defendant number 2 issued letter memo number so and so dated 13/7/1992 to ASO.
Just a minute. Page 8?
Of the plaint.
Para?
Memo of appeal.
Para?
Para 7.
Was there any order?
Actually, this suit was also ex parte. Not ex parte, defendant did not contest.
You did not contest.
Contested, but did not file it.
You did not file written statement.
And actually, this suit land, there are land measuring, total land measuring
1 bigha,
1 bigha, 1 katha, 14 lakhs. Out of which 3 katha land has been allotted to us.
1
only.
bigha, 1 katha, 14 lakhs, total.
Total.
Yes.
3 katha has been allotted to us.
Yes.
And 2 katha they are possessing. Still there are more land, more than that land.
It's wrong statement, my lord. Only vacant land is a three katha, my lord.
That question has not been decided whether it was a vacant land or not. And that question was not also raised that there was only vacant land of 3 katha. If that be
Now, what
so,
is the decree for?
my lord,
The decree which has been granted. It
only
is
2
for,
katha.
no, what is the decree?
Decree for 2 katha Kindly see the schedule, my lord. Schedule also vague.
No, no, let us,
District Dhubri, page 10, my lord. Gauripur Circle, Dhubri, Gauripur Town, Dag number 157, old 203, area 2 katha, out of 3 katha, 1 lesser.
what is the limitation for for instituting an execution?
12 year.
When was the original
Decree,
decree, the appellate court?
appellate court.
91 months. 2399.
2399.
The appeal was by whom? You?
No.
Initially, the suit was.
Initially, suit was dismissed, then appeal.
Title Appeal 93 of 1979.
79.
70.
Decreed when?
Decree
2399. First 12 matter.
2/3/1990.
91.
1991.
And when this suit was filed, at that point of time, limitation was there.
When was this present suit instituted?
It was instituted on in the year 2002.
2002. You had time to go for an execution.
22/1/2002. Judgment,
You could have filed an execution. Why didn't you file?
yeah.
I am objecting only, my lord, demarcation matter. At this type matter. Yeah, so
See, if you insist on that, the bar will come again. And even that is not the, rightly so, that is not the part of the suit. Otherwise, the suit would have been barred by law.
in this case matter, in this suit matter, in the 2002 matter,
Hmm.
the execution has been filed. Second,
What has been filed?
execution has been filed. That's a case. The second suit, the earlier not.
Now we have not defaulted. We have learned. The execution of what decree?
Second point, second thing.
What decree for what?
Declaration and
Injunction regarding?
in the suit level.
What was the injunction? Permanent restraining the defendant from evicting.
If it people they come for demarcation matter. Only vacant land is 3 katha matter.
You are individuals or you are also cooperative society?
No one. I'm individual. Matter.
Individual. How did you, what was your source of title?
From 1969, my land.
Source, title.
I'm possessing the land, my lord, since 1969. My
No title.
title as will be by the court, my lord. I have decree has been filed in our favor.
No, how did it come? You just possessing government land.
Lord.
If we ask more questions, I think it will go against, further questions will go against you. We thought you are a Myadi Patta holder. You are only possessing.
Possessing, my lord, in the year
But Mr. Ghosh, if you are having 2 kathas of land as per
No, 3 katha.
3 katha, then they are enjoying in the 2 katha, why are you evicting them?
Not, we are not evicting.
Hmm.
There is question of eviction does not arise. Because there is a clear cut boundary with a boundary wall also there. And this boundary wall was constructed by the government. At
So where is
sanction
their,
of the government.
where is their apprehension? Apprehension comes from where?
Apprehension only that when we want to demarcate the land by putting the boundary wall.
Yeah, we have already done.
Already done. By the government, not by me
The
also.
question is not
It-
3 katha and 2 katha, but
And,
Now, are you in position of 2 kathas or not?
not.
Then what is your
and
difficulty?
big go down
He,
is there.
Mr. Ghosh is saying that he's very
Yeah.
happy in his 3 katha. Boundary
No.
wall is there.
The allotted land is 1 katha, my lord, to them, my lord. But in the ASO report, my lord, for demarcating for 3 katha upland.
They are saying that their boundary wall is encompassing 1 katha or 3 katha. How are you worried? Why should you be worried if your 2 kathas of land is
Right.
intact?
And government also constructed big go down over that the land in the land of the consumer and cooperative society.
Okay. ऐसा विप्लव. Heard Sri S.K. Ghosh, learned counsel for the appellant, who has the instant appeal has been preferred under section 100 of the Code of Civil Procedure against a judgment and decree dated 23/6 so and so, huh? ওটা এখানে লিখে দিবা ভুল করেছি না The present appellant is the defendant number 5 in the suit. Please have your seat. Para. The suit was filed with the following prayers. Page 10. Huh? Page 10, A, B, C, D. Full stop. It has been projected in the suit that in respect of the suit land, comma, the plaintiff had instituted title suit 15 of 79, which was however dismissed on 1/9/79. Full stop. Being aggrieved, comma, a title appeal number 93 of 1999 was preferred.
79.
You have written 99. No? So it should be
Wrongly typed.
79 was preferred before the learned ADJ, which was also dismissed. Full stop. The plaintiff had accordingly preferred second essay number 179 of 1987 and 180 of 1987 before this court. Full stop. This court had, however, remanded the matter for a fresh adjudication by the first appellate court. Full stop. On such remand, comma, the first appellate court had decreed the suit by interfering with the judgment and order of the trial court dated 1/9/1979. Full stop. The present defendant number 5 was, however, not party in the said suit. Full stop. Para. The present suit from which this appeal has arisen was subsequently filed in the year 1990, 2002,
2000.
2002, with the prayers which have already been mentioned above. First of, the learned trial court had decreed the suit, which has also been affirmed by the first appellate court by the impugned judgment and order dated 23/6/2009, and accordingly, the present second appeal has been preferred. Full stop para. This court, by order dated 7/12/2016, had framed the following substantial question of law. Order dated 7/12. Para. I have heard Sri S.K. Ghosh, learned counsel for the appellant. Full stop. I have also heard Sri J. Laskar. A. Mubarak. A. Mubarak, correct. Learned counsel for the respondents. Full stop. It may be mentioned
Only
that
respondent number 1 file.
Hmm?
Legally at the respondent number.
that is it. No, for the respond numbers 1.1, 1.2, 1.3, and 1.4. Full stop. It may be mentioned that during the pendency of the appeal, comma, the respondent number 1 had passed away, and the aforesaid respondents are his legal heirs. Yes, any state council. Sri T.R. Gogoi, London, if he is there, kindly inform him, Mr. T.R. T.R. Gogoi, London State Council, is present for rest of the respondents. Full stop para. Sri Ghosh, the learned counsel for the appellant, has submitted that the predecessor of the present respondents, that the original respondent number 1 in this appeal had the option of filing execution proceeding in respect of the decree passed earlier, which was not done, which was admittedly not done. Full stop. He submits that only to overcome the lacuna, comma, the instant suit was instituted. Full stop. It is submitted that such suit, the learned counsel questions the very maintainability of such suit when remedies in law were available to the party which was not taken recourse to. Full stop. By referring to section 34 of the specific relief act, comma, the learned counsel for the appellant has submitted that under the proviso thereto, there is a bar, and this aspect has been overlooked by both the courts below. Full stop. Para. Regards the learned counsel has submitted that the plot of land in the possession of the defendant number 5, which is a cooperative society was duly allotted by the Assistant Settlement Officer Dhubri in the year 1993. Full stop. He has also pointed out that such allotment was never challenged in any forum of law, and he further submits that since a bar is there in the Assam Land and Revenue Regulation, in the present suit, there was no specific challenge to the said order of allotment. Full stop. The Learned Council has clarified that the land in question has already been demarcated with boundary walls, and in fact, the apprehension of the respondent plaintiff is based on assumption. Full stop. Para. Free Mubarak, the Learned Council for the respondents above named, has however defended the impugned judgment and decree of the first appellate court, by which the judgment and decree of the trial court has been upheld. Full stop. He submits that there is no bar in institution of the suit, and the proviso thought to be proviso to Section 34 of the Specific Relief Act 1993 thought to be relied upon by the appellant would not come into operation in the facts and circumstances of this case. Full stop. The Learned Council has also submitted that the total area in question consists of 1 bigha, 1 katha, 14 lechas, and while only 1 katha of land was allotted to the appellant, they are in possession of 3 kathas of land, and therefore the apprehension of the eviction or disposition of the respondents were based on materials on record. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. The decree which was passed in Title Appeal 93 of 79 on 2/9/1991 is exactly on the same subject matter of the present suit. Full stop. It is there is nothing on record to show as to why the said decree was not put to execution within the time prescribed by law. Full stop. The default on the part of the present respondents in initiating an execution proceeding cannot be rectified by filing another suit, that too for the prayers which have already been mentioned. Full stop. This court is also of the opinion that apart from indulging in multiplicity of proceedings, comma, a matter which was already adjudicated cannot be reopened for a fresh adjudication, full stop. Though the strict application of the doctrine of res judicata may not be applicable, as the present appellant was not a party in the earlier suit, comma, this court is of the opinion that filing of a fresh suit would not have been done only to overcome the aspect of not initiating an execution proceeding qua the judgment and decree dated 2/9/1991 passed in title appeal 93 of 1979. Full stop. Para. This court has also taken note of the submission of Sri Ghosh, the learned counsel, that the demarcation has already been done and the appellants are in possession of the area allotted to them. And the respondent numbers and the aforesaid and the contesting respondents are also in possession of the land which was the subject matter of the suit. Full stop. Para. In view of the above, comma, this court is of the opinion that the appellant has made out a case for interference. Full stop. Accordingly, both the judgment and decree dated so and so are set aside. Full stop. The substantial question of law framed by this court, a substantial question as quoted above is accordingly answered in favor of the appellant and against the contesting respondents. Full stop. Appeal accordingly stands allowed. Send back the records. Yes.
My lord, state
Okay. Mr. Bhattacharya, we're recording your name, State Council.
In particular, they are 12 till 5.
Yes. Sixteen and 17, sub-use. Other side? Other side? Not two. 16, 17. Who's for the other side? No idea. Okay. Yes, Mr. Luster.
my lord, this second appeal, my lord, has been preferred against the judgment and decree dated, my lord, 29/5/2008, my lord.
No, that is okay. Appellant is, there are two appeals.
Two appeals, my lord. One appeal is, my lord, against the suit. I have filed the suit, my lord.
No, that you are the appellant.
My lord.
Appellant is a plaintiff.
Plaintiff, my lord.
Okay. Suit for?
Suit for right title, declaration of right title, arrest and recovery of possession.
Yes.
Suit was dismissed, my lord.
Suit dismissed.
Suit dismissed, counterclaim also dismissed, my lord.
Suit dismissed. And they had instituted as a counterclaim.
Counterclaim, my lord. That counterclaim, my lord, was also dismissed by the learned trial court.
Yes.
Against the, my lord, suit. Dismissal of the suit, I have filed appeal, my lord. That appeal is also dismissed.
Title appeal dismissed.
And the defendant respondent hearing, my lord, they also filed, my lord, appeal, my lord, against the
Counterclaim.
counterclaim.
That was
That was allowed, my lord.
appeal. Defendant.
So my
Allowed. So
RSA 53 is against the, my lord, appeal filed by the plaintiff appellant.
appeal against the dismissal of your suit.
Lord.
And RSA 54 is for
54 is against the counterclaim.
allowing of the counterclaim by the first appellate court.
Lord.
Okay.
My lord, the substantial question of law, my lord,
Yes.
that was formulated by this honorable court, my lord, is on, my lord, 3/6/2009.
3/6.
2009
Which case?
in RSS 54 months, 54 and 53. Both of it.
3/6. Three six. What I hear, Bila? What does it quote it? 3/6. The substantial questions of law were framed in one appeal.
In 53, my lord, 53 and 54 also.
54, there are no substantial question of law. আছে নাকি? 3/6 or order and item. 3/6, there's an order in 53.
Not.
But no substantial questions of law were framed in 54. It would have said. Yes.
My lord, for the sake of convenience, my lord, I want to take RSS 53 first.
Yes.
The appellate court judgment is at page 5.
Page 5.
Lord, page 5.
Yes. It is 29/5.
My lord, it's 29/5, 2008, man.
Title appeal 19.
Title appeal 19 of 2007.
Okay. This was your appeal
My lord,
against the dismissal of the suit.
against the dismissal of the
And
suit.
this appeal has also been dismissed.
Dismissed, man. My lord, page 2, my lord, internal page 2, page 6. 956.
Page 6, yes.
0.3, my lord. Second paragraph. I have scrutinized the pleadings of title suit number 24 of 2006 and also deciphered the documents submitted by both the parties and also heard both the sides on memorandum of appeal and for appropriate conclusion of the appeal. The learned appellate court, my lord, did not frame any point for determination in the appeal. It is required under Order 41, Rule 31. Not a single point of determination, nor issue-wise discussion. Just 2 pages, my lord, in a cryptic manner, was the imprint judgment.
What has been violated?
My lord, the core issue, my lord,
What has been violated? Where is the requirement?
Order
of-
41, Rule 31. May I read? Order 41, Rule 31. The
Yes,
judgment-
that we know. Yes, please read if you want to read.
The judgment of the appellate court shall be in writing and shall state, point A, the point for determination, the decision thereon, the reason for the decision, and where the decree appealed from is reversed or buried, the relief to which the appellant is entitled, and shall at the time that is pronounced be signed and added by the judges or by the judges concurring there. But there is no point for determination, my lord, as per Order 41, Rule 31. Nor issue was discussion with clear mind.
No, but if the points of determination do not specifically framed, if from the discussion it appears that the relevant matters were discussed,
Yes, yes, my or
then
be-
will it vitiate the entire judgment?
no, my lord, if the entire materials on record,
Exactly.
then
Yes, but you say that issues are also not been discussed.
the issue is not discussed and not, my lord, the discussion is there, not point for determination. And my lord, if we go, my lord, the core issue, my lord,
Let us read paragraph 4. I think 4 will
my lord, my lord,
cover everything.
my lord, my lord. It appears from the judgment and decree passed by the learned assistant district judge on 19/2/1996 in title suit number 62 of 1992, Exhibit Go, that the suit land as described in the schedule of plaint was part of the suit land, which was included in the schedule of the plaint of title suit number 24 of 2006. Well, there are 2 suits. One is, my lord, 62 of 1992,
That is earlier suit.
earlier suit, my lord. And present suit is, my lord, 24 of 2006. Therefore, it indicates that the suit land as described in the schedule of the plaint of title suit number 24 of 2006 has already been decreed in favor of the defendant respondent way back on 19/2/1996. Therefore, the instant suit is hit by the law of res judicata due to the confirmation of right title, interest, and possession of the respondent over the suit land. My lord, if I take your lordship to exhibit Go, my lord, then, my lord, title suit number 62 of 1992, my lord, it is in between, my lord, Mahadev Urang, my lord, where my name, my lord, plaintiff's name, and the plaintiff vendor not in this suit, my lord. It's quite different, my lord. Parties are different. My lord. They are not parties in the earlier suit.
You contended the earlier suit were between different parties, not you, not involving you.
Not
Who
different
was the defendant there? Who was the plaintiff?
plaintiff was my lord, Sri Mahadev Urang, my lord, and Srimati Sanda Urang.
Was between, no, who it was, the suit was between Mahadev Virang
Mahadev Urang and Pradeep versus Pradeep Kumar Ship.
against Pradeep.
Pradeep, Srimati Umarani.
Who are you?
I am my lord, different person, my lord. I am not.
Who is Madhav Virang?
Mahadev Urang, my lord, is the father of.
No, Mahadev is also a party in your suit.
My lord, Mahadev is the party. He was the plaintiff. He was the plaintiff earlier too. But my name is not there, my lord.
No, but in the present suit where you are a party, that was also instituted by Mahadev Virang.
Mahadev Muram against not me, my lord, but others.
Okay.
Pradeep,
But it is is it the same suit land?
same footland, but different part.
Huh?
Different part. Covered by bag number and patta number, my lord. While
Area is different.
area is different. Area is different, but a portion of the land I have purchased.
And what was the description of the land in the earlier suit?
Description of the land, my lord. The earlier suit was for declaration of possessory right, my lord.
What was the description of the land?
Dark number, my lord, 162. Oh, dark
Earlier
number-
suit,
earlier suit. 80 and 81, dark number.
Earlier suit. Doug?
Covered by dark number 80 and 81.
Okay.
And my lord, patta number 162.
Okay.
And area of land, my lord, 6 chatak. 1 chatak.
6K, 1 chatak.
Lot. 6 chatak, 1 chatak.
Okay. And your area?
My area is, my lord, my lord,
Doug number?
second arrest, patta number 162.
Patta is
Tag number, my lord, 80, 81, 82.
same tag number.
Area 3 kata, 11 chatak.
3K, 11 chatak.
3 kata, 11 chatak.
Okay. And what about the schedule?
Schedule, my lord. Schedule is in the eastern part, my lord. My schedule will be, my lord, in the eastern part, there is a nala, there is canal water. And west side, my lord, PW road. North, my lord,
But
dependent
are you contending that the area was different?
area, my lord, not exactly different, my lord. But I was not a party there, my lord. And land is, my lord, some of a portion. my
Are
lord.
you connected with the other party in the earlier suit? You are Radha Raman Das.
I am Radha Raman Das.
Are you connected with Pradeep?
No, my lord.
Hmm?
No, my lord. Neither I am,
Pradeep is not your relative.
no, my lord.
Your vendor?
No, my lord.
From whom did you purchase this land?
I have purchased from my Krishna Urang. Krishna Urang is the my lord, son of Sukram Urang. So he was a my lord tenant under my lord L. Chandra Singh. First, my lord Shukram Urang was a tenant under L. Chandra Singh, my lord. I am his son, my lord.
Okay, let us read the discussion again in paragraph 4.
Well,
It appears. Page 6.
of physics. It appears from the judgment, my lord, and the decree passed by the learned assistant district judge on 19/2/1996, entitled suit number 62 of 1992, exhibit 1,
Yes.
that the suit land as described in the schedule of the paint was part of the suit land, which was included in the schedule of the paint of title suit number 24 of 2006.
Mm.
Therefore, it indicates that the suit land as described in the schedule of the paint of title suit number 24 of 2006 has already been decreed in favor of the defendant, respondent way back on 19/2/1996. Therefore, the instant suit hit by the law of res judicata due to confirmation of right title, interest and possession of the respondent for the suit land. Further, it has surfaced that the suit is also paid for non-joinder of necessary parties, especially the other co-sharers of the patta who are not made parties to the suit. It has also come out that the will made by the predecessors of the respondent was duly probated, and he became the owner of the entire property purchased by his predecessor. It has also revealed that the suit land is in possession of the defendant respondent. Moreover, the appellant could not show any document authenticating the setting aside of the order dated 19/2/1996 passed by the learned assistant district judge entitled suit number 62 of 1992. Furthermore, from exhibit O, Go, Ngo, Cho, Tho, and To, it appears that the right title, interest, and possession of the suit land is in favor of the respondent. Moreover, it appears that the Khatiyan number 52, exhibit 1, was a Kacha Khatiyan, which does not confer non-effectibility status to the appellant. Besides, the registered deed number so and so, which was registered on 3/3/2004, was also the certified copy, and therefore does not seem to hold much water, as the document regarding the suit land produced and proved by the respondent were executed much earlier
clearer.
than the said registered deed. Moreover, it appears that exhibit 6 and 7 are photostat copies and were not proved with the original and therefore not admissible in evidence. So, my lord, I have purchased the land by exhibit 5, my lord. Exhibit 5.
Yes.
And exhibit 4, my lord, is my vendor's sale deed.
Your purchase by exhibit 5 is a registered sale deed.
Registered sale deed. Registered sale deed, which was executed, my lord, on 3/3/2004, my lord.
And your vendor had purchased from?
Purchased from, my lord, please from my lord, Mukti Singh, my lord. Mukti Singh, a descendant of late L. Chandra Singh, who was the, my lord, landlord, and under the landlord Sukram, my father was there. Subsequently, my lord, Sukram's son is Krishna Urang, my lord. Krishna Urang subsequently, my lord, inherited the father's is under the my lord, landlord of Elsing, subsequently also purchased the proprietary right. Mukti Singh, my lord, and handed over possession. What happened, my lord, on 11/4/2000, when I have purchased, my lord, the food property,
You purchased on 3/3/2005,
2004, my
2004 or 5?
2004,
Hmm?
2004, my
4.
2004, my
Registered sale deed.
well, well, I have purchased from Krishna Urang. My lord, what happened, my lord, after purchasing of the property, my lord, there was a, my lord, house
Hmm?
in that property, my lord.
There was a house.
There was a house. And after purchase of the property, my lord, and possession was handed over to me, I have taken possession and I am deciding in suit, including the house, wherein the house standing.
You have been residing there.
Decided there, my lord, peaceful. But what happened, my lord, on 11/4/2004, my lord, the defendant, along with some miscreants, my lord, attempt to dispossess me, my lord, from the suit land, my lord, and ultimately, my lord, suit land and the dwelling house. Ultimately, my lord, I filed an FIR before the police station, my lord.
Hmm.
Police, my lord, without, my lord, registering my FIR case, rather arrested me and all the male members of my family, and my lord, disposes the female members. My lord. All the female members,
Hmm.
those who are residing, my lord, they have been disposed by the police. That's why, my lord, I have filed this suit.
Now, disposition was on the strength of what? You had lost the FIR.
I have lost the FIR that someone
Yes, then arrest under what case?
arrest, my lord, on a false pretext, my lord.
Who has lost the case?
My lord,
There has to be a case where you are arrested. It cannot be that you are arrested in your own case.
own case, my lord.
Then
No.
they had also instituted a case.
Police in their own initiative, my lord, without filing an FIR, my lord, from the side of
How
the
can it be? Somebody,
police has
somebody has reported. It may not be a formal FIR, but if information reaches the police, they can.
police should have started a case, my lord. Instead of that, my lord, I have been arrested. My family, main members are arrested. Anyway, my lord, that's why I have filed this title suit. Learned trial court, my lord, has held that he is barred by res judicata. But res judicata would not affect in case, my lord. Will not come into operation. As parties are different, I have no connected with earlier suit. And another, my lord, peculiar, my lord, thing is that though Kotian was issued, my lord, learned trial court has held that if Kotian was issued in the name of someone, then why the Kotian holder will not pay rent, etc. to the landlord? My lord, in this connection, my lord, I take your lordship Assam temporarily settled areas Tenancy Act 1971, my lord,
Hmm.
section 55, 57, 58. It is the duty of the government, my lord, under what process they will take all the initiative. And rules is there, my lord. The rules 28, 30, 31, 30, and form number 19 is also there. What will be the rank, how, under whom the Patian holder will come there, that record. This is the duty of the government settlement officer. So one substantial question of law, my lord, in this respect has also been formulated. That's a substantial question number 2, much.
Yes. Let us see the substantial question, number 1.
My lord, whether the impugned judgment and decree passed by the learned court below, dismissing the suit filed by the plaintiff appellant for recovery of possession on the basis of previous possession over the suit land, in holding that the sale deed, that is exhibit 4 and 5, by which the plaintiff appellant purchased and got possession of the
Hmm.
suit land are secondary evidence, and as such not admissible in evidence are purpose and unsuspected.
Please read again. Whether the impugned
Whether
judgment.
the impugned judgment and decree passed by the learned court below, dismissing the suit filed by the appellant plaintiff for recovery of his possession on the basis of his previous possession over the suit land, in holding that the sale deed, that is exhibit 4 and exhibit 5, by which plaintiff appellant purchased and got possession of the suit land are secondary evidence, and as such
Not
not
admissible.
admissible in evidence are purpose and unsustainable in fact. My lord, exhibit 5, by which I have purchased, and exhibit 4, my lord, by which my vendors are purchasing the suit property. And second, my lord, whether the impugned judgment and decree passed by the learned court below, holding that payment of rent is required to be made to the landlord even after Khatiyan was issued to the vendor of the plaintiff under the Assam temporarily settled areas Tenancy Act, are purpose and unsustainable in law.
Yes. Third.
Third, my lord, whether the impugned judgment and decree passed by the learned lower appellate court, holding that the suit filed by the appellant plaintiff is barred by res judicata, and thereby decreeing the counterclaim filed by the respondent defendant without taking consideration of the respective issue in both the suit, and particularly the issue of recovery of possession of the suit lands by the plaintiff appellant on the basis of his previous possession over the suit land, are purpose and unsustainable. So, my lord, the core issue, my lord, whether I was in the possession of the suit land earlier, that has not been decided. That not a issue was framed, and not a discussion at all by the appellate court.
That we have said. But where is your substantial question of law pertaining to Order 41, Rule 31?
My lord,
At the initiation of your arguments,
Lord,
you had pointed out a provision of law that law mandates that the first appellate court is required to frame particular points for determination amongst the four requirements. There is no points for determination fixed. But where is that question?
That substantial question of law has not been there. But your lordship is there, my lord. Your lordship can mind. If your lordship finds that it is a captive manner, learned appellate court pass the opinion order, then your lordship.
There is no further observation of this court that any further substantial question of law may be framed. Unlike all the orders, normally we
That, that is not there.
that observation, but that will not be an absolute bar for framing further questions. We
Not-
can frame.
Yeah, yeah.
Uh, There are decisions, Mr. Luster.
Lordship.
Are you
My lord, yes, lordship. One thing, my lord, that is,
in position of any such decisions?
my lord, I want to take your lordship, the page, my lord. It looks 31, my.
Mhm.
They are written statement. In the written statement, my lord, they have also admitted that Kram Urang. At page 31. Last, my lord, C.
Read section 105. Where is the CPC?
My lord.
Where is the code? Code of civil procedure.
Yes, my lord.
Read section 105.
And 105.
100, subsection 5.
My lord.
Please read.
The appeal shall be heard on the question so formulated. And the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question,
Then proviso.
provided that nothing in this subsection shall be deemed to take away or abridge
Or a bridge.
the power of the court to hear.
Hmm.
For reason to be recorded, the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. Fine.
Very good. We'll take a short break, Mr.
Fine. Fine.
But please try to
Good.
get hold of the learned counsel for the others. So Mr. H. Sarkar, he is there, and Mr. S. Bhattacharjee.
I'm inquiring.
Please try to inquire.
Fine. Fine. My junior colleague has done much.
Now, from the reading, it appears that it might be a case for interference. In that case, I
Not
think there, and it's a matter of 2008, we are not going to adjourn these matters.
2009.
9.
Yes.
Okay, let us complete your part at least.
Fine.
Ready? Sundar. সুদীপ তো ভট্টাচার্য জি আছে এসআর ভট্টাচার্য বার কাউন্সিলর মেম্বার সিম্বল হয় দত্ত নহয় ভট্টাচার্য অলপ শকতকে গোলমুখ পাৰিলে ফোন কৰিব লাগে বা হেৰিত দিব পাৰি না ইয়াত পাৰি না দিব অঁ ডিছপ্লে তিনিজন উকিলৰ নামটো Yes.
Well, I want to take your logic. Some temporarily settled experience acquaintance also.
Yes.
Section 55 matter. Section 55 matter. Page 669. Chapter 10.
Just a minute, please. $55 is power to order preparation.
Power to order preparation of record of right for tenant.
Yes,
Or may I read that?
yes,
The state government may, where a settlement operation under chapter 3 of and revenue regulation 86 is not being carried out at any time, make an order in the case of a local area, estate or part thereof, directing that a records of right with or without survey for all or any class or classes of tenants be prepared by settlement officer. My lord,
yes, sir. Anything? Okay. Okay. We were wondering, this is a contested matter. Tomorrow there will be many matters. Let him come, we'll accommodate him. If it is not possible today, then maybe. But because this bench continuation, we do not know in the next week. Or we do one thing, we stop for some time. There's one matter, yesterday's matter, we'll complete that, MSc matter,
my
I
lord,
think, by sleep. Then once Mr. Bhattacharya come, we'll accommodate you.
My
And
lord.
since we have already heard in length,
my lord.
we do MSc to this by sleep facility. One short matter was there. লাগিব, huh? Yes.
This case lordship, extra editing from the government took place lordship. We had talked that so both are so that this that's
Very good. Are you applying the correct multiplier, Mr. Saikia?
Yes.
You are, okay, very good.
But only thing that I have oral instruction notes, but in writing, I need it. So written instruction.
Now we'll decide this then, we're having the same, we'll maintain the amount which you have agreed upon. We'll decide it, very small issue. Have you got propensity today? What was it, 22.9 or 29? What was the paragraph number?
Paragraph number, my lord, multiplier has been my lord,
22.9. What was the paragraph number?
paragraph number, my lord, user prospect paragraph number, my lord,
Multiplier.
multiplier, my lord, should be taken from the Sarla Burma.
Propensity, what are you saying, Mr. Manav? Everything has been taken care of in propensity. There is formulation of the points. Why don't you go by there? There's only one paragraph, 22, I think.
My lord, age group, my lord, 26 to 30, multiplier come, my lord, 7.
No, your contention that it is the victim, not the claimants. That has been beautifully explained here. The 59.7. Why didn't you read 59.7? Age of the deceased should be on the basis of applying the multiplier. This is by a larger bench. Everything has been taken into consideration. The instant appeal has been preferred under section 173 of the Motor Vehicles Act in respect of a judgment and order dated 16/5/2014 passed by the MACT Kamrup Guwahati in MSC case number 1055 of 2006, whereby an amount of rupees 2,41,000 along with interest at the rate of 6% per annum has been awarded. Full stop. The appeal is filed by the claimant for enhancement of the award. Full stop. Para. The claim was instituted by the claimants on the accidental deaths, on the deaths of their sister in a motor accident on 19/2/2006 involving the vehicle number, bearing number AS01X8958. Full stop. The respondents had contested the claim by filing written statement. Respondent insurance company. However, the owner cum driver did not contest the claim. Full stop. The claimants had adduced evidence through two numbers of witnesses, whereas no evidence was adduced by the insurance company. Full stop. Amongst the documents which were proved, the following documents were proved in approved before the tribunal. Paragraph, page 3, paragraph 4, exhibit 1, 2, 3, 4, pass সখন আছে। Full stop, para. The learned tribunal, vide the impugned judgment and award, had vide the impugned judgment and order.
One lordship, we had reduced DW was there.
DW was there?
Yes.
Where?
Page 7 lordship of judgment.
Why have you written no DW, Mr. Manaf, in the memorandum appeal? Page,
Page 7 of judgment.
internal page 7.
Yes.
Where? Oh, yes. Yes, you're correct. And the insurance company had examined one witness, namely the investigator. Not absolutely, the learned tribunal, by the impugned judgment and order, had awarded the amount of rupees so and so, huh? Oh, 2 lakh আছে, what the লিখিছিল, as mentioned above, full stop, para. Amongst other grounds, comma, Sri Manaf, the learned counsel for the appellants, has submitted that the multiplier applied is 13 by considering the age of the claimants,
Right.
which is not in accordance with law. Full stop. It is submitted that the deceased being 28 years of age at the time of death, comma, the correct multiplier is 17.
Seven.
Full stop. In this connection, comma, the learned counsel has relied upon the judgment of the Constitution Bench of the Honorable Supreme Court in the case of National Insurance Company Limited versus Pranay City and others, reported in 2017, 16 SCC 680, full stop. It is submitted that the view expressed earlier in the case of Sarla Verma was reiterated by the Constitution Bench, full stop, para. It is submitted that if the correct multiplier is applied, comma, the amount awarded would be enhanced, full stop. Para. Per contra, comma, Sri A.J. Saikia, learned counsel for the insurance company, has however submitted that the learned tribunal had overlooked the aspect of dependency qua the claimants upon the deceased, full stop. It is, he submits that from the materials on record, it would be clear that the deceased was the sister of the claimants, and the claimants were not dependent upon the said deceased, and therefore, and this factor was wholly overlooked by the tribunal, full stop. He accordingly submits that the award is on the higher side, full stop. Para. With regard to the aspect of the correct multiplier, comma, the learned counsel for the insurance company has, however, fairly considered that the multiplier should be as per the age of the deceased, as clarified by the Honorable Supreme Court in the aforesaid cases, full stop, para. The rival submissions have been duly considered, full stop, para. The impugned judgment while coming to the awarded amount had applied the multiplier of 13, full stop. As per the statute, comma, the age of the deceased being 17, being 28, comma, the correct multiplier should have been 17, full stop. The Honorable Supreme Court in the aforesaid case of Pranay Sethi Supra has, comma, in the context of the multiplier to be used, to be applied, has laid down as follows. Paragraph 59.6, huh? No, 15, no, 59.6 or 59.7, full stop, para. As regards the submissions made by Sri Saikya on the dependency factor, comma, this court is of the opinion that in absence of any appeal by the insurance company or a cross objection in the present appeal, comma, that aspect is not liable to be gone into by this court, full stop. And therefore, court as the said aspect has attained finality, full stop, para. Considering the aforesaid facts and circumstances and following the law laid down by the Honorable Supreme Court, comma, the impugned judgment and order dated so and so passed by the learned so and so, in so and so stands modified to the following extent, full stop. The for an extent, the multiplier which was applied as 13 is modified to be modified to be 17, taking the undisputed age of the deceased, full stop. The total the compensation therefore would be calculated 2 rupees. How much?
My lord, has been, my lord, agreed, my lord, 260, my lord, some amount, my lord.
Have you paid him
Yes,
the
50% entire awarded amount is
what would be the balance amount only? The balance would be remaining.
No, my lord, total amount, my lord, 2,41,000 along with, my lord, interest already been paid.
Yes.
Now, my lord, another further, my lord, amount 2,60,000 would be paid. It has been agreed.
Another 260.
Another 260.
Have you made the calculation? Hmm?
But judgment
No, other aspects we are not touching. But by change of the multiplier from 13 to 17, will there be a double of the amount?
if it is taken 17, then amount will come to 3,06,000.
3,06,000. 241 you have already paid.
My lord, what happened, my lord? Multiplier, my lord, 17. And my lord, future prospect is to be taken into consideration. Future prospect will come 40%. If multiplier, if my lord, age of
No,
the disease,
no. What are your grounds here?
my lord,
Future prospect you may not.
Pronosticity provided for the same, but appeal memo lacks it. Appeal memo, there is no fix.
We'll not go into the aspect of Mr. Manna of the future prospect. We are only what is apparent from the face of it. We are
it was, my lord, But in my appeal, my lord,
Let us see where.
grounds of the appeal. But in fact, my lord, we are agreed, my
No, Mr. Sakya says we cannot record his agreement.
Yes, sir.
Though an agreement has been arrived at between you, but his agreement is on the basis of oral instructions.
My lord,
If Mr. Sakya, we can record your thing, that will not be proper.
Written,
Um,
instruction.
Then we
lord,
can say oral instructions.
Written instruction.
No, we can say, we can record as oral instructions. We can clarify that no written instructions are there, but he has been already instructed.
Let's say,
Okay. 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 Tara, what are you? So Manaf, the Learned Council has also raised the issue of grant of adequate compensation on the aspect of future prospect. Full stop. Full stop. That last of it, huh?
that has
But-
been held in the trial court also. The
Okay.
purpose court also.
So he submits that the aforesaid factor was also taken into consideration by the learned tribunal. Full stop. Para. That's the modified, full stop, para. Considering that the claim is of the year 2006 pertaining to 2006, this court 6, and this court being informed that the awarded amount has already been paid, this court directs payment of a lump sum amount, of a lump sum additional amount of rupees 260, 260,000, which however, 260, the said amount is to be released within a period of 45 days from today, failing which the same would accrue interest at the rate of 9% from annum, 9% per annum. Not now. Make it within payment within 45 days, no interest.
Payment should be deposited before my, yeah, on my lord.
Wherever
Definite.
you say,
wherever he's convicted.
it is for which place, the MSCT?
MSCT, my lord, in Kamrup, my lord.
Kamrup,
My lord, member 1, my lord.
Let it be here.
Yes.
The amount may be deposited in the registry of this
My
court,
lord,
which would be released to the claimant on being properly identified.
Obla.
Okay. I think issued to DDO.
May it please, Lord. My lord, your lordship may see the order dated 24/4/2024.
In IA,
IA 2303.
3042.
2303 of 2022. IA.
I believe it as an IA.
Order passed by Justice K. Sema.
Yes. 24/4.
24/4.
Yes.
Lord, your lordship can see the second para. Right, order dated 11/8/2022. It was ordered that the judgment and order dated so and so passed by the learned member MSCP shall remain state till disposal of the appeal subject to deposit of 30%. Then the next para. Today, when the matter is called, it has been submitted by so and so that the insurance company is yet to deposit 30% of the awarded amount as ordered on. My lord, submission I made on that day, there was some miscommunication between the company and me. My lord, in fact, they have deposited way back on 18/8.
Okay. Doesn't matter then.
Now, therefore, my lord, what I propose, the entire case is ready, record has come. Any day in the next week, your lordship may hear the entire matter.
What
Because
is
it is
your, Mr. Talukdar, what do you say?
My lord, this order attains finally.
Which order?
This one. If you kindly have a look, 2 weeks time is accordingly next paragraph granted to Mr. S. Dotto,
Yes.
learned counsel for filing the necessary application. It is made clear that if no application is filed within the time allowed, MSC Appeal 451/2022 shall stand automatically dismissed.
But the amount was already paid.
Well, amount out of the amount, my lord, 11/8/2023 IA case regarding stay, Honorable Court has directed the appellant to deposit 30% of the awarded amount
Hmm.
within 6 weeks
Yes,
before the registry of the site.
correct.
Accordingly, the appellant did not deposit the said 30% amount before the registry.
So what would be the worst
Now, what
consequence?
had happened on
Mr. Talukdar, suppose he has not made the payment, what would be the consequence, the worst?
my lord, let me.
Will the appeal go?
I respectfully agree. On 24/4/2024, my learned colleague has, on misconception of fact, has submitted the same.
Correct.
I have profound respect upon him. But this appellant has deposited the money on 24/4/2024, 5 days before the registry of the height.
My lord, possibly he did not read the order.
Yes. Appellant deposited the amount of 12,18,628,
When?
30% of the awarded amount on 24/4/2024.
No, it was deposited on 18/8/2022.
18/8/2022.
22.
Yes. Now, my lord,
Mr. Talukdar, why are you harping on these issues? Contest the case, matter ends there. 30% has been deposited, it's a matter of fact.
if it is deposited, my lord, let the court allow to withdraw the state amount, my lord.
You make this prayer, we'll consider.
Yes.
You are going on some other
Since
tangent.
it is deposited, let this matter.
My lord, the question is, this matter is covered by the decision of this honorable court. Now, whatever your lordship is already aware, there is a notification by the state government way back in 2017 that when a deceased, my lord, they die, after that period, then till the date of their expiration, they will be getting their entire pay and allowance. So therefore, this honorable court say that so far dependency assessment is concerned, it is all over. Only thing in regard to future prospect, then my lord, the other conventional amount and all that, they are eligible to get. To extend to that extent, my lord, I will, my lord.
Mr. Doctor, see, there may not be a loss of income till the time when he retires,
My lord.
because he'll be getting the family members will be getting the full salary.
Yeah.
But from the date of the retirement, when family pension would come,
They will get family pension.
family pension. So from that date, we can probably the difference of the pension which you have got and
Yes,
family
yes.
pension,
That's
that we
a-
can
that's a-
calculate.
That's a different issue altogether, my lord.
No, this is a very issue which is it's been faced by most of the tribunals.
Right.
We are aware of it.
Right.
That because of the scheme, actually there is no loss of income.
No loss, even your lordship proposing that aspect is very correct.
Yes.
But what the tribunal is doing, my lord, they are getting the family pension. Now, as if they construe
No,
that,
there is no loss of income. Rather, the amount which the deceased employee would have consumed or utilized on his own, that is also being now left for the entire family.
now, my lord, the loss, how much they will incur, say family pension up to the age of 67, the full family pension they will get. After 67, there will be some difference. Say 10,000 per month, now they are getting.
Okay, we'll clarify this part, then we'll have this for hearing.
Yes, yes. Any day, my lord, I am ready.
Well, in the meantime, this at least amount may be released.
How much is the amount?
My lord, the amount we have deposited, 12 lakhs.
18,
My lord, 12 lakhs, 18,000. My lord, I will concede to 6 lakhs, up to 6 lakhs.
my lord, 6
Possibly even they will not get to that extent
This
also.
12 lakhs to 18,000 is 30%.
30%.
Yeah.
Okay, we'll say something. Okay. Heard 3 as doctor.
6 lakhs is very less, my lord. Some more amount may be.
My lord, if they are eligible, they may get the entire amount.
Are you getting the full salary or not?
No. Yeah, I am getting my. But
Then this
family has some difficulty.
this cannot be a windfall. The MSCT is not windfall. It's not a lottery. It's only a codification of a tortious liability
Exactly.
that will be calculated. Earlier matters are different. Now the scheme of the state government, till the date of the superannuation, you get the full salary. So there is no loss of income. The other factors are different, the mental pain, agony, but those have also been quantified by the Honorable Supreme Court. There is
Yes.
no question of any going this way or that way, all quantified. Heard Sri as Dr. Learned Counsel for the Learned Senior Counsel for the you're the appellant.
Appellant.
The appellant assisted by Sri your Siddhant Subhan Datta. Also heard Sri I.A. Talukdar, Learned Counsel for the claimants respond numbers 1 to 4. Full stop para. At the outset, comma, the senior counsel for the appellant, by referring to an order dated 24/4/2024, passed in IS Civil 2303 of 2022, has submitted that due to miscommunication, comma, a submission was made on that date that the deposit of 30% of the award was yet to be made. Full stop. Under those circumstances, comma, the insurance company was directed to deposit the directed to file necessary application for review of the order dated 11/8/2022, by which such deposit was directed to be made. Full stop para. The senior counsel has, however, submitted that as a matter of fact, the deposit of the 30% was made on 18/8/2022, and this fact was not communicated to him by the clients, which resulted in the situation on 24/4/2024. Full stop. He has also placed before this court a copy of the communication dated 18/8/2022 to the Registrar General of this court, whereby 30% of the awarded amount was deposited by check number 578122 dated 18/8/2022 of the Axis Bank Guwahati. Full stop para. In view of the aforesaid clarification, comma, this court is of the opinion that the condition imposed by the order dated 11/8/2022 was duly fulfilled. Full stop para. At this stage, comma, the senior counsel has also submitted that the issue involved is a very important issue which is required to be adjudicated. Full stop. He briefly he has submitted that the issue concerns the calculation of the compensation of a government servant who dies in harness, and as per scheme of the state government, comma, till the date of superannuation, comma, such government servant is entitled, the family of such government servant is entitled to full salary. Full stop. He accordingly submits that there is no loss of income as such, and this factor has not been taken into consideration. Full stop para. The senior counsel accordingly submits that since the records have also been received, comma, the appeal can be taken up for final disposal. Full stop para. 3. I Taruk, the learned counsel. However, submits, however, submits that he would make appropriate submission at the time of hearing on the issue raised. Full stop para. The learned counsel for the claimants, however, also praised for release of the amount deposited in terms of the order dated 11/8/2022. Full stop para. 3. Dr. the learned senior counsel has, however, objected to the aforesaid prayer by contending that the award in question is extremely erroneous because of the, in view of the submissions made above. Full stop para. Be that as it may, comma, and in the interest of justice, comma, this court directs release of an amount of rupees 7.5 lakhs out of the deposited amount to the claimants by the registry of this court. Full stop. Such release be made on being properly identified by the learned counsel for the claimants.
My lord,
Much obliged.
IA number 3899/2023 is disposed of by virtue of this order.
3045, 3042.
3899. Which was
3899, yes.
50%.
ये order इसमें भी लिख देना. In 399, in view of the order passed today in the appeal, in the connected appeal, comma, appeal, this IA stands disposed of.
Obliged.
3899, okay. This will make copy of the main copy of the communication dated 18/8/2022 is made part of the records.
And money already been deposited before the registry of the act.
18/8 it was deposited. Huh? 30? 3899 dispose हो जाएगा. ये सब रहेगा ऐसे. আৰু কিছুমান IA. Mr. Dutta, the other IA can be disposed of. 2303?
Yes.
2303 is for what?
It's for
Oh, this was already,
This is stay.
no,
This is my stay.
stay was already
Yes.
disposed of.
Yes.
And the other one,
otherwise 3042, my lord.
what is that for?
This is my for release of the 50% amount.
That is disposed of.
Disposed already.
And 3899? Condonation, that was already
I think
disposed
it
of.
was all over.
Okay.
Open.
3042 will be disposed of. Okay. 3042 ही होगा, बाकी से पहले हो चुका है.
Item 26.
26. Yes, Mr. Das.
I thought of expertise has been, but still have filed it. I have brought it on record by slip.
You are enjoying a stay order.
Yes, sir.
Are you filing, have you filed any application for vacating?
No doubts.
Last date, why didn't you make a prayer for extension of the stay order, Mr. Counsel? Don't make that mistake. Would like to file anything?
But the take up the matter for fine. We have filed a
Transfer. Transfer of what?
transfer of restitution of conjugal rights. Section 9 petition from Guwahati to Kinsu.
Your
I'm the husband.
wife has come before
Wife.
this court. You reside where? In Guwahati?
Yeah.
from Guwahati to Tinsukia. You reside at Tinsukia. Okay.
And on the contention raised by the petitioner in the it is the expenses to bond, and the husband is ready to pay the regarding her.
Now, why have you explored the option of video conference?
Uh,
You take instructions.
Yes.
Honorable Supreme Court is very time and again encouraging this. This all can be sorted out by video conference.
Yes.
No expenses, nothing, no inconvenience also.
Yes.
Wife is staying at Tinsukia.
Yes, sir.
You have any issues? Children?
Yes, this is small child, but less than 1 year old.
Less than 1
One
year
and
old.
1 year.
Tinsukia, you are staying at your parental home. No divorce proceedings.
No.
Why didn't you come back to your husband?
So there is some like mental, even physical torture by the husband.
No, have you instituted a divorce proceeding? You have not.
No, okay.
no proceeding accept.
See, restitution, if you want to contest a restitution, there has to be some overt act from your side that I cannot live with this person. I have filed a divorce. But you cannot just say that, I don't know, I'm not going to stay in the matrimonial house. You have a child. Welfare of the child is of paramount importance. Okay, when do you want?
Company, we have filed a
Oh, you have filed affidavit. Okay.
No, stay maybe continue.
Stay will continue, but till the next day. What is your name?
Rahman.
A. Rahman.
Yes.
You're not there on
On
record.
Yes.
On behalf of whom?
Etna.
I heard Sri A. Rahman, learned counsel for the petitioner. Also heard Sri D. Das, learned counsel for the respondent, who submits that the affidavit in opposition has been filed today.
Yes.
Full stop. Para. Para, considering that the application is for transfer of a proceeding for restitution of conjugal rights, comma, list this case for admission hearing. When?
It's not a convenience.
So immediately on reopening, 16th.
Yes.
16th of July. Immediately on the reopening of the summer vacation. On 16 July 2024. Immediately likhna, huh? 16 July 2024. Interim order passed earlier to continue till the next date of listing.
Let's try to explore it.
Yes, please explore video conference.
And you
I think to maybe taken on next Tuesday, my lord, because I have some cervical problem. I'm going to doctor, my lord. Maybe taken on next Tuesday, my lord.
Next Tuesday. It's an old matter, Mr.
Yes, that
Karma.
is true, my lord, but I'm ready also in this case. But
Yes,
due to
Mr.
some-
Amna. What is this?
Judgment has been already, judgment and decree has been passed in a manner. Some issues were decided in favor of the plaintiff. They filed the execution case, they got them. 3 issues were decided in negative against them. Those 3 issues are in the appeal.
Subject matter of this appeal.
This-
First appeal also they lost.
No, this is the first.
partly allowed.
Oh, this is RFA, okay.
This is our.
Okay.
Otherwise, for the issues which were decided against
Okay.
in their favor, execution has been followed.
Okay, he has some
they got-
difficulty today. We'll have it
But-
on Tuesday.
but-
Tuesday, but we'll have it.
Tuesday, my lord.
Okay. Sri J. Sharma, learned counsel for the appellant, submits that due to some medical reasons, comma, the matter may be adjourned. Yeah, don't say medical, there's some personal difficulty, comma. The matter may be adjourned.
Well, if it is not inconvenient for on 23rd.
Also heard Sri D. Nath, standing counsel PWD. For para, considering that this appeal is of the year 2013, comma, a short accommodation is granted, directing listing of this matter on
20.
20.
Twen-
This,
Okay.
okay. I didn't read.
Please, your lordship.
Yes, Mr. Sandeep.
There is a second appeal of reversal, my lord.
Yes,
Earlier, my lord, appellant is the defendant, my lord.
yes.
And earlier the suit was dismissed, my lord, by the first court. And while appeal, my lord, appeal was reversed, my lord. My lord, substantial questions of law were framed on 18/2/2015, my lord.
18?
2015.
Appellant is the
Defendant,
one defendant.
my lord.
Suit for,
One plaintiff, one defendant, my lord.
Suit
Both are
for?
others, my lord.
suit for,
Pardon?
suit for,
Suit for declaration of right to attenuate interest, my lord. Suit
Yeah.
for declaration of plaintiff's half share in the suit land and building with partition and separate position of his share and for permanent injunction. my lord.
not right title.
Not
Declaration of,
exactly, my lord, but in the prayer, my lord,
declaration in the half share.
my lord, half share in the suit land,
It's a more of a partition suit.
more of a partition suit, but the plaintiff's claim is that, my lord, his father has gifted this property to him, my lord.
Okay, we'll have to. But second half, there is a full bench.
Oh.
And we have to rise early also. We do not know how many matters will be. No, this probably will be able to tackle your matter. You have been waiting for long, we'll finish your matter.
Yep.
Rest matters I find difficult today. I do not know how long full bench, then some deliberation. And 3:15 will rise. Let's see. And the one matter is already there, Mr. Laskar. Yes, have you informed? No, he was informed. Somebody said Mr. Bhattacharya was supposed to come. Sudipta Bhattacharya. Yes. Yes.
Actually, one of the respondents died, so we don't have any specific.
My lord, there is a sole respondent, my lord.
Okay, you come back at in the second half.
My lord,
Be
before writing,
here.
my lord,
Yes.
I have a prayer.
Yes.
The item number 9, today's list, my lord. Matter may come up after 2 weeks, my lord. My learned friend has given consent, my lord. Because
Item
correct
number?
9, my lord.
Matter of which year, madam?
Matter of 17.
Okay. Take us about.
Not
2 weeks, it will be vacation then. We don't want to adjourn a matter of saying, okay, we'll give a date. We'll accommodate. Court master will give a date.
After vacation then. my lord.
Yes, he'll give a date.
After vacation.
No, we are here at, we'll come in the second half. Don't worry.
After vacation then.
After
Head to head to do.
Oblige, my lord.
All right, my
Where is he? Mr. Bhattacharya's colleague? Yes.
Yeah.
Okay. We can have it some other day
My
then.
lord,
When? It's a old matter.
2009, my lord.
When?
After vacation,
After vacation, matter is.
we need to get instruction, the son died as per the permission
No,
of
no.
our advocate from Thailand.
2009 matter.
My lord, one thing, there is the sole respondent was there, my lord. I have brought to the notice of this court by imputing the legal head. I have filed, my lord, I have noticed served already, my lord. Is there.
No, if you do not have the instructions to appear, then we'll proceed. Now, did you take steps on the?
Steps already taken, my lord. Notice served, my lord.
Okay, then we'll
There
proceed.
is a lodgement
If you appear, you appear. Otherwise, item number, you want to see it? 16, 17. Both these appeals arise out of the same impugned judgment and order passed by the first appellate court. Full stop. Sri T.U. Laskar, learned counsel for the appellant, is present. Full stop. However, comma, a prayer for accommodation has been made on behalf of Sri S. Bhattacharya, learned counsel, who had appeared for the original respondent. Full stop. Para. Considering that this appeal is of the year 2009, comma, a short accommodation is granted, directing listing of this matter on, we'll have it on 19th. 19th we'll see, and if he has some difficulty, otherwise we'll proceed. 19th.
19, my lord,
No, not 19th, 20th, 20.
20.
Thursday.
My lord, can it be on 21st?
Friday.
What?
Friday it will not be possible.
Then, my lord, 25th.
No, last week will not fix a hearing matters.
Oh.
Let it be on 28th. You're here or not? 28th, 20.
My lord,
Okay. 20th, 20, 26. Next Thursday.
Fine. Hello, my lord.
Biswa, huh?
My lord.
Yes, Mr. Sundi.
I was the defendant, my lord.
You're the appellant is the defendant.
Defendant,
Suit
my lord.
for declaration of half share in
My
the
lord.
suit land.
Partition and separate position as per the first title, my lord. But in the plain, my lord, they have claimed the title in on the strength of a gifted, my lord.
In the
Yes.
relief sought for in the plaint.
In the plaint itself, my lord.
No, in the relief sought for, in the prayer portion or what?
No, in the body of the plaint also, they have stated that the suit land, half of the suit land was gifted to the plaintiff by his father, my lord.
Okay.
Plaintiff and defendant are brothers, my lord.
Okay.
My
That's
lord.
okay.
Lord, the substantial questions of law, my lord.
No, the suit was decreed.
Suit was dismissed, my lord.
Suit was dismissed.
Suit was dismissed, my lord.
Which court?
My lord, the court of Munshi, my lord, Puliabur.
Just a minute, please.
It was dismissed
Just a minute, please.
on 8/7/2014.
TS, that was TS 13 of 13K.
Yes, my lord. Sorry, my lord. Yes, my lord. Case number is that, my lord, and
TS
judgment and
13,
decree,
13K,
my lord.
2011.
11, my lord.
Dismissed on 34/2013.
14, my lord.
34/14.
13, my lord.
13.
First title,
13 by
14,
the Munsif.
my lord. Munshi Puliabur, Nagaon, my lord. They have preferred appeal, my lord.
Title appeal.
Title appeal number 27 of 2013.
Title appeal 27 of 2000 by plaintiff.
Yes, my lord.
By plaintiff appellant.
Plaintiff appeal.
Okay. Then what happened?
Then, my lord, that appeal was allowed, my lord, by the judgment and decree dated 8/7/2014,
14.
my lord, 14.
TA 27 of 23, 27 of 13 allowed.
My lord.
Okay. And you are the aggrieved party now.
Now, my lord. My lord, the substantial questions of law were framed on 18 through 2015, my lord.
Yes, we have seen.
My lord. May I go to the first judgment, my lord? Very brief judgment, my lord. I will not go to the facts of the entire case, my lord.
Just a minute, please. Where page?
Page 15, my lord. Page 16 starts, my lord. Facts are only stated in two paragraphs. May I read, my lord?
Page
It will make-
15.
My lord, page 16. Relevant page, my lord.
Just a minute, please. Trial court judgment is 30th of April.
My lord.
Okay. Yes, which page?
16, my lord. Only in two paragraphs, my lord, facts has been
Yes.
stated, my lord. May I read, my lord?
Yes.
That the plaintiff and the defendant are two sons of late Potikpora, that after the death of Potikpora, his property devolved upon his four sons, including the plaintiff and the defendant and his wife. Late Potikpora, however, during his lifetime, gave share of his landed properties to his daughters also. It is the further case of the plaintiff that landed property consisting of the residential house of their father, which is more specifically described in the schedule of the plaintiff, has been gifted to both him as well as the defendant equally in two parts after giving delivery of possession. However, after the death of Potikpora, the defendant illegally occupied the above suit property, and in spite of repeated requests, the defendant refused to vacate the plaintiff's portion and even did not allow the plaintiff to enter into his portion. Hence,
But there were four sons.
four sons, my lord, and two daughters, my lord.
The division was between the amongst the four sons.
They have, my lord, they have not stated in details in the plaint regarding those things, my lord, but they have stated in the WS.
But be that as it may, whatever has been stated in the plaint,
my lord,
the division was made amongst four sons.
all the
and
property all
and
the
daughters.
all the property.
And the allegation is that defendant had encroached upon the part which was given to the plaintiff.
Which was plaintiff has stated that, my lord, out of all the properties, my lord, this scheduled property was gifted to plaintiff and the defendant half, my lord. Now, my lord, his allegation that I have encroached upon his half share, my lord.
Okay.
But
that is it. Whatever is the original family arrangement had stipulated a particular share on the plaintiff.
My lord.
And on the death of the father, you had encroached upon his land.
My lord, that's the case. But he has stated in the plain that, my lord, he has acquired his right by way of a gift deed, my lord.
Okay.
His suit is, although, my lord, in the cost title, he has given the suit as, my lord, partition suit, my lord. And may I continue with the
four sons, wife, and daughter.
My lord. Two daughters.
Two daughters, where is it written? Daughters.
Daughters.
Daughters, then share of land to plaintiff and defendant. What was the schedule of that land?
2 bigha, 12
No, no, schedule, was it marked in a schedule? Schedule what?
Schedule A, my lord.
Schedule A.
My lord. Just
Schedule A consists of both portions.
Only schedule is mentioned, my lord. Schedule.
No, schedule.
Yes, my lord. 2 bigha, 12 letters, my lord.
This is the entire plot which is amongst plaintiff and defendant.
Defendant, my lord.
Okay. Schedule is 2 bigha.
12 letters, my lord.
That means 1 bigha, 6 letters were your respective part.
My lord.
And after on the death of your father, you had encroached upon his 1 bigha, 6 letters.
My lord, that is his
that
case,
is his case.
case, my lord. But he stated in the plain that he has acquired the right by way of a gift deed, my lord. Gift.
Okay. Where have you stated?
In the plain, my lord. Plain is that relevant paragraph is page 7, my lord. Paragraph 7, my lord.
Okay. Then what happened? Yes, please.
My lord. May I read the paragraph?
Yes, please. Continue.
That the scheduled property is the exclusive property of the plaintiff and the defendant jointly as gifted property from their father, and the defendants have no right, title, interest over the entire property, and to refuse to vacate half portion of the scheduled property, and the defendant illegally denied plaintiff's right, title, interest thereon, and so the plaintiff has been compelled to file this present suit for declaration and partition.
Yes.
My lord, this is the main case, my lord. The defendant's case is that, my lord, there are many properties, my lord. The plaintiff has also got his share of his property, my lord.
Okay. Then, yes, then what happened?
Defendant entered appearance, filed written statement stating that there is no cause of action, my lord.
Yes.
Page 16, my lord.
Yes, yes.
Is not maintainable, is barred by law of limitation, is bad for non-joinder of necessary parties, is not property valued, etc. Defendant denied the allegations made by the plaintiff and stated that no deed of gift was executed by their father. The defendant claimed that after the death of their father, he, along with other three brothers, got separated, and all of them used to reside in separate landed property of their father, and that he used to possess the suit property by residing thereon with his family. It is further claimed that as he has filed a suit against the plaintiff in respect of a plot of land at Jakalabanda town, the plaintiff has filed the instant suit. Thereafter, issues were framed, my lord. Then, my lord, next page, my lord, discussions and reasons and my lord. Issue number 1, 2, 3, my lord, may I skip, my lord. These are basically related to cause of action, maintainable, and barred by limitation, my lord.
Okay.
That's not relevant. But next, issue number 4, my lord.
Yes.
The defendant in his written statement has pleaded that non-joinder of all the legal heirs of the late Potikmara has made the suit bad. The instant suit has been brought by the plaintiff against the defendant, claiming his joint title over the suit property on the basis of the same being gifted to him and the defendant by their father. Hence, the above circumstances and the other heirs of the late Potikmara cannot be said to be necessary parties in the instant suit. The issue as such is decided in favor of the plaintiff. This is issue regarding, my lord, whether the suit is bad for non-joinder of necessary parties, if it is to be taken as a suit for partition, my lord. The court has rightly held that, my lord, since it's not the case of partition, my lord, so other parties are not necessary parties, my lord. Then, my lord, issue number 6, my lord. Next page. The plaintiff in the instant suit has claimed his half share in the property on the basis of gift being made to him and the defendant by their father, and the plaintiff has relied on the Jamabandi Exhibit 1. The plaintiff in his evidence claimed that their father did not execute any gift deed in their favor. The defendant, on the other hand, claimed that no gift deed has been executed by the father. The plea of the...
No, please read. The plaintiff in his evidence claimed that their father did not execute.
My lord. In the plain that, my lord, state that, my lord, he has gifted, my lord. But no gift deed was there, my lord.
Oh.
The plea of the plaintiff that no gift deed has been executed in their father has, however, been contradicted.
No, I think there is some error in this, because defendant, on the other hand,
my lord,
maybe he has said, the plaintiff in his evidence said that father did execute.
My lord.
Hmm.
The plea
and
of,
which,
then, my lord,
this execution of the gift deed was denied by you.
My lord.
Okay.
The plea of the plaintiff that no gift deed has been executed in their favor has, however, been contradicted by PW3 Latmandal, who has exhibited and proved the Sitha of Tatial village exhibit number 10. In his evidence, PW3 has stated that in exhibit 10, it is mentioned that both the plaintiff and the defendant has been gifted the land covered by Dak number so-and-so and periodic patta number so-and-so by way of 2 registered gift deeds by their father, late Potikmara. In the instant case, the plaintiff has, however, not produced the deed of gift and has based his claim on the strength of mutation of his name on the Jamabandi, that is Exhibit 1. Section 123 of the Transfer of Property Act states that for effecting a gift of immovable property, transfer must be effected by registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. The same is lacking in the instant case. Mere mutation of the name of the plaintiff in the Jamabandi without any document of title will not enable the plaintiff to get a title over the suit property. The plea of gift having remained unproved, the plaintiff is not entitled to get any relief. Well, it is the judgment of the lower court. Now, my lord, appellate court has on appeal what has done, my lord, only going by the pleadings of, he has not given his decision issue-wise, my lord. Stated the entire fact and the findings, my lord, the appellate court has arrived is that, my lord, page 37.
But this conclusion at issue number 6,
my lord,
and the discussion, don't you think that there is some inconsistency? Issue number 6, while discussing, he has been consistently writing, the learned judge, that there is no assertion from the plaintiff that there was a gift deed. He's been writing that there is no assertion. He did not say that there was any gift deed. The Lat Mandal, he came as PW3. He said, no, there is a gift deed. as if it is to confront the PW.
No, my lord, PW has stated that there was a gift, but gift deed was not executed, my lord. That's the whole case, my lord. Because as per the section 123, my lord, oral gift deed is not admissible, my
Now
lord.
that is okay, but last line, the plea of gift having remained unproved, plaintiff is not entitled to get any relief.
Yes, my lord.
If the plaintiff had put up a case that there was a gift, but there was no deed,
My lord.
there is no case. You
My
cannot have a gift with
My
without a deed.
My
It's not it's a Hindu law,
My
not a Mohammedan
My
law. So that was his projection.
My
But contrary to what he has stated, one PW came the last month and said there were registered gift deeds, 2 gift deeds.
As per the note mentioned in Sita, my lord.
Yes.
As per the note, but there was no gift deed exhibited, my lord.
But he
On the last Mandal, my lord has come and said that, my lord, there was a note, my lord, regarding all the plots, my lord, of the father of the Petitioner Bora, my lord. But that cannot be a basis for allowing a gift deed, my lord. As per
okay, the learned court had gone to the extent that since the gift deeds, the basis of the mutation was not proved.
My lord.
So mutation itself will not be conclusive to come to prove the title of the
My lord.
plaintiff.
My lord. Now the appellate court, my lord, while delivering the judgment.
But that was that could have been easily the conclusion could have been easily raised. Plaintiff never said that there was any deed.
But plaintiff said that, my lord, it was gifted.
Gifted by what? He did not say there was a gift deed.
But if it's a suit of partition, my lord, then all the parties are necessary and all the properties are also necessary to be included, my lord. Now, my lord, without reversing that issue of non-joinder also, my lord, the appellate court cannot reverse the judgment, my lord. The appellate court presume that, my lord, it is a suit for partition, my lord. That's why, my lord, he is entitled to a half share of that scheduled land only. But, my lord, plaintiff and defendant both are stating that, my lord, there were lots of plots of lands, my lord, which will be divided between their sons and daughters, my lord. If that is the case, my lord, if that is their case, my lord, then, my lord, it's a suit of partition, and in that case, my lord, all the legally and necessary parties, my lord. It's a suit then back for non-joiner necessary parties, my lord. Without inclusion of all the properties and all the legal heirs, my lord, cannot be decided that one portion, only one land, my lord, he is entitled to half of that, my lord. Because there is no evidence that, my lord, who has got what portion of land, my lord, other land, my lord.
Regarding non-joinder, you may have a point, but regarding the other properties, that may preclude a subsequent suit under 2.2.
What, my lord?
Non-joinder may be a valid point, but so far as non-joining of the other properties in a partition suit, that may be a bar for any subsequent suit under Order 2, Rule 2. But can it be a bar for the suit as such, the present suit?
Yes, my lord, because, my lord, we are not stating that, my lord, if it's a suit for partition, my lord.
Order 2, Rule 2.
My.
Please read.
Yes, my lord. The order to suit to include the whole claim.
Yes.
Every suit shall include the whole of the claim which the plaintiff is entitled to make it in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court.
Okay. Then
relinquishment of part of claim, where the plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished.
See, it may be a bar for the subsequent suit.
But, my lord, for that, my lord, the other legal heirs cannot be agreed, my lord.
That's a different point. We are on non-joinder, we have not said anything.
My lord.
But
here in
regarding not having the other properties part of the suit,
yes,
that may not be an absolute bar.
But
non-joinder, yes, non-joinder, yes, we do not know.
In partition suit, my lord, there is judgment, my lord, your lordship also knows, my lord, in partition suit, my lord, all the legal heirs and all the properties should be part of. Otherwise, my lord, cannot be distributed equally.
All the legal heirs, yes, all the properties, the bar will come under 2.2. 2.2 may be for a subsequent suit. You have
In
read.
my humble submission, in a partition suit, my lord, this bar will not apply for my lord, because
No, this bar.
my lord, that is there, but
That's
if
a-
that other
Okay, okay,
properties
then
are not
you-
included,
No, non-gender, you have a point.
my lord,
Yes. But in any case, this issue was decided against the plaintiff
my lord,
by the trial court.
by the trial court.
Okay, then
Then the appellate court, my lord, in absolute violation of order 41, rule 31, my lord, without discussing the judgment issue wise, my lord, simply, my lord, stated all the facts and evidence and come to a finding, my lord, at page 30, that is at page 37,
37.
37, 57.
Yes.
Here the Jamabandi, page, paragraph 29, my lord.
This is the part of the trial court judge, appellate court
Appellate
judgment.
court judgment. Here the, may I read, my lord?
37,
Paragraph
29.
29. Here the
Yes.
Here the Jamabandi copy and evidence on record shown that the name of legal heirs of Fotik Bora mutated in respect of each Sag as per distribution of properties of late Fotik Bora during his lifetime, and therefore I do not find any ambiguity in the entries made in the Jamabandi as per amicable distribution which is made by Fotik Bora during his lifetime. The suit properties distributed on plaintiff and defendant equally. Hence, I hold that the plaintiff is entitled to half of the suit properties, and he has right title in interest in respect of the half of the suit properties, and is also entitled partition of his share and first position in respect of half of the suit property. That's the finding, my lord. Now, my lord, the appellate court has taken it as pure of, my lord, partition suit, my lord. Because, my lord, but however, my lord, as per the plain, my lord, the plaintiff has claimed to right over the half of that plot of land, my lord, scheduled land, my lord, by way of a gift, my lord. And if that is so, my lord, then there has to be gift deed, my lord, registered gift deed, my lord. And in my humble submission, the learned first court, my lord, the court of Munsif, my lord, has rightly held that, my lord, since it's a case based on gift deed, my lord, without having a registered gift deed, my lord, and without delivering question, my lord.
But he was not praying for a declaration of title based on the gift deed.
But in that case, my lord, he has not said that, my lord, it's a suit for partition. In that case, my lord, all the legal heirs must be there, my lord. You cannot say that, my lord, all are given other properties and only I am allowed to have half share of a plot of land, my lord. When entire property is of 25 acres, my
Let
lord.
us see your WS.
My lord.
Page?
Page, my lord, 11, my lord.
No, WS is 11, okay.
My lord. There was no cause of action for filing the suit. The suit is not maintainable in its present form. Plaintiff has no right to file the suit. The suit is barred by limitation. Suit is barred for non-gender of necessary parties, as all the legal heirs of Petitioner Bora has not been implemented in the suit. The suit is not properly valued and no proper court fee has been paid. Suit is not properly signed and verified. Suit is barred by principle of waiver and averments made in para 1 of the plain term matters of record. Averments made in para.
Was non-gender of parties an issue?
Yes, my lord.
How was it answered?
Yes, my lord. That was page, my lord. Page number 17, my lord. Issue number 4.
Non-gender.
That's what I was submitting, my lord. The appellate court has not reversed this finding also. And that is, my lord, strictly non-compliance with my lord, order 41, rule 31, my lord. The appellate judgment has not, my lord, given a single word on the issue. Simply stating the facts and evidence, my lord, he has given his findings in a paragraph, 2 paragraphs, my lord. which itself is illegal, my lord. The being a court of first appeal, my lord.
Madam Chakraborty, the discussion of issue number 8 and issue number, issue number 4 and issue number 6
Yes, my lord.
by the trial court, which Mr. Sundi has read. Let us again read it at page 17.
Yes, my lord. Issue number 4.
4.
Whether suit is bad.
No, the answer to the issue number 4.
I'm
discuss.
sorry, yes, my lord.
Page 17.
Issue number 4. The defendant in the written statement has stated that non-gender of the all other legal heirs of late Patitioner Bora has made the suit bad. The instant suit has been brought by the plaintiff against the defendant claiming his joint title over the suit property on the basis of the same being gifted to him and the defendant.
Okay,
by the
here,
father.
pause here for a moment.
Yes,
This issue has been answered in favor of the plaintiff. That if you kindly turn over the page, so it is answered in favor of the plaintiff.
yes, my lord.
The basis of this answer is the assertion of the plaintiff that it was a gifted property
Gifted property by
Roof.
father.
by the father.
Father.
But at the same time, the discussion of issue number 6
Yes.
says that the gift was not proved.
Yes, my lord.
So don't
No.
you think that these are contradictory?
Now, yes, my lord. And that issue also not framed before by the.
Which issue not framed?
That-
Non-gender is an
Under
issue.
section 23, if there is any gift deed to be registered under section 123 of Personal Property Act, the issue is not framed. Without framing only this,
No, it's not a question of whether the gift deed was registered. The
Okay,
question
yes.
is whether there was a gift deed at all.
my lord, this is the amicable settlement of the family property, my lord. During the lifetime of the father, he distributed all property among his all children. So this portion, the scheduled suit land is given to both the appellant and the.
That is not your projected case, that there was an amicable family settlement, family arrangement. You
No.
said that this suit land was the land which was gifted by your father. It is not a family arrangement amongst all the legal heirs.
As per him, it is gifted by father to both the appellant and the respondent.
Correct.
Now the appellant raising this is not entitled for the half share of that property. If he is claiming that this is a joint property between the appellant and the respondent, or the plaintiff or defendant, then if I am not entitled to get the half share of the property, how the appellant got this property? Where from he got this property?
The suit is not by him.
No, my lord. This is he said earlier in the year 2000, my lord, in the memo of appeal para 17 in order judgment dated 8/7/2014 in para 17, it is already mentioned that in the year 2010, the appellant filed a title suit number 10K of 2000, but this is not in record and it was not again challenged. The 10K 2000 against the claiming the share of land.
That's a different suit.
No, my lord. If I am,
Which page, madam?
my lord, in my objection in his RSC, he hasn't given this copy of the order. In my written objection,
Page.
judgment page 8. Judgment dated 8/7/2014.
No, which page of this compilation?
Compilation is,
My lord, just filed an objection to the appeal, my lord.
my lord, take 5 minutes to compile.
Written objection, my lord.
I filed my written objection in this case, my lord, in page 55 of my written objection.
Written objection to what?
So, my lord, the judgment,
Objection to what? Objection for an appeal?
no,
Under what provision of law you file objection?
already I raised objection, my lord, as I am submitting the objection orally, my lord, it is written here, in title suit, what has happened and the.
Madam, you can give your written submission. That's a different matter. Where is the scope of filing pleadings in an appeal?
No, my lord, in appeal, I cannot file a affidavit in opposition. But in written objection, written submission, I think
Written submission is a different matter. It's not filed. It is presented to the court for consideration. If you say written objection, it is filed in the registry.
Submission, my lord. It is my written submission.
Okay, what have you said?
So in my para 17 of my written objection, judgment dated 8/7/2014 at
Page.
55.
Page,
55 of my written submission.
internal page.
I was an
Internal page 8.
appellate judgment, my lord.
Appellate judgment, para 17.
Internal page 8.
And written submission page 55. Continuous page 55.
55, okay.
55. Internal page of the judgment.
The lordship will also get in the appeal memo also.
Yes, let me finish first. What I am
Appeal
submitting.
memo te aste.
Yeah.
Note
In
aste.
para 17,
Hmm.
evidence of PWD 1, Tarikant Bora stated that they are 4 brothers, 2 sisters, and disputed land in their parental property. He stated that he has not filed the suit based on a gift deed. He further stated that though his father gifted the suit land, but no gift deed executed.
Mhm.
He further stated that his brother defendant in this case, Sam Chandra Bora, filed a suit which is numbered as PS 10K 2000 against them, claiming his share of land. So, if I am not entitled over the suit land, for argument's sake, assuming that on the basis of the gift deed, I am not entitled. Then, if it is a joint property under DAG number 782, which is not challenged, not take any statement against the Jabamandi or Chita. No, they have not filed any objection. Even their written statement also, they have not raised about the objection against the gift deed. They have not mentioned. But in the issue also, no gift deed, question of gift deed or registered gift deed, whether the plaintiff is entitled to get the half share of this land without having a registered gift deed, this issue could be put in time. But this issue is not there. On the non-gender of this party, when the issue number 4, when the municipal court showed that the gift deed to him, the defendant by father held in the above circumstances other legal here of late Patitioner Bora cannot said be necessary party in this instant case. If it is gifted, so question of joining of the other legal heirs of the deceased Patitioner Bora does not arise. He currently taken decision on the basis of this. The appellate court also observed.
What is your reaction on the second substantial question of law
My lord,
pertaining to non-joinder of necessary parties?
not this question, yeah. When
Admittedly, you are
if
four brothers
four
and
brothers,
2 sisters.
2 sisters, they have no raised any objection when the suit is pending before this court.
They have raised an objection. Non-joinder was an issue also.
This is the non-gender is of the issue is raised by the appellant.
Yes.
None other legal brothers and sisters.
No, they are not even.
In the evidence of the other
How can a
brother-
party in the suit say that no, I have not been joined? He is already there.
No, my lord. Deposition of the defendant in appellate court, my lord, that already evidence of the other brothers have been taken, my lord. They have not raised any objection. This is here also, my lord. PW2 in my written submission page 56. Evidence of PW2. This is the brother of the Hemchandra Bora and the Tanikanta Bora. They are all brothers. Hemchandra Jatin, para 19. Evidence of PW2, Jatin Chandra Bora is he. Defendant and plaintiff are all sons of Patitioner Bora. Their father died in the year 1987, leaving him his brother Hemchandra Bora, Devendranath Bora, and the plaintiff and 2 daughters, namely Dayamati and Bhuvaneshwari. And their mother Pratima and mother died in the year 1989. He deposed that after death of the Patitioner Bora, all properties devolved upon his 4 sons, and after death of his wife, her share also devolved on them. And his father, late Patitioner Bora, is the owner of the suit property. He further opposed that, as per Exhibit 1, Pratik Chandra Bora gifted the suit property to plaintiff and Hemkanta Bora in two parts. Father can gift any property between any children. So he divided this suit property between two sons. Already his brother admitted it. In cross, he stated that there are 4 brothers and 2 sisters, and all were got equal share on the father's property and should land in their parental property. He further stated that his father during his lifetime divided landed property to all children, and accordingly he got the properties of Tatyal. Plaintiff and Hamchandra Bora got the old house. Plaintiff has also got properties at Guru Bhugia and Daduri, and all his division took place 30 years ago. Now, my lord, evidence of DW1, Hamchandra Borua, the appellant, at page 57, para 21 of the judgment. Evidence of DW1, Hamchandra Bora is that his father, late Pratik Chandra Bora, had landed properties measuring 2 bigger 12 places of land with 2 stories wooden residential building where he is now residing. He stated that his father never executed any deed of gift and delivered possession, and during lifetime of Pratik Chandra Bora, his sons separated their own consent, and after death of Pratik Chandra Bora, the state separation was finally effected and plaintiff left for Gorubhugia near Chakalabanda, where he had constructed separate residential house in the land belongs to Pratik Chandra Bora. All other sons of late Pratik Chandra Bora separate and used to reside at separate house of the land left by late Pratik Chandra Bora. He stated that his father was Jamidar. He deposed that they are 4 brothers, 2 sisters, and at the time of their parents, all the brothers living in the food property and land is measuring 2 bigger 12 places of land, and there is 1 story wooden present.
2 stories.
2 stories. 2 stories wooden house present. In cross, he stated that his father during his lifetime gifted some landed properties to all 4 brothers, and suit land is gifted to him by his father. He denied that suit land is given to him and his brother Tanikanta Bora. He himself admitted, this suit land is given to me and my brother.
He denied that.
No, my lord. He denied that suit land is given to him and his brother Tanikanta Bora. He stated that he do not know whether in Exhibit A it is mentioned that he and Tani got the property by gift. He stated that he received a notice from the plaintiff and plaintiff sought his share of land. He stated that there is no partition made on those properties which are not gifted to them by their father. If it is not gifted to Hemchandra Bora, and he is occupying this properties, and now Tani Bora is claiming on the basis of his father gifted to him also in joint property, which is evident from Jamabandi and Chita, which was not challenged by the appellant. This is contrary, it is fraudulent, it is totally made, but it was not challenged. It is in the Jamabandi, in the same suit land, both the brothers' names are there. So, my lord, in this case, my lord, the appellate court also observed that in the suit patta in para 25 to 35, PW2 is the brother of plaintiff.
20?
PW2, para page 59,
Yes.
para 25. PW2 is the brother of plaintiff and defendant. He deposed that his father gifted suit property equally in between plaintiff and defendant. His brother is admitting this property is distributed between the 2 brothers, plaintiff and defendant. The plea of plaintiff and defendant made in the hearing and evidence further take it clear that late Pratik Chandra Bora during his lifetime distributed his properties among his children, and after going through the oral evidence, there is nothing to disbelieve that late Pratik Chandra Bora has not distributed this property among his legal heirs. In the suit patta, there are There is as many as 70 numbers of tag, and total land is 25 bigger, 3 kata, 10 lesser top land. As per Jabamandi, name of the Hemkanto Bora, and mutated in place of Patikchandra Bora in land of tag number so and so. Name of dependent Devendra Bora mutate in the land of tag number so and so. Name of the Jyotin Bora mutate in the respect of tag number so and so. In the tag number 76, in the name of Tarini Bora, in the respect of land of tag number 772 and 782, 1446, 1541, name of the Hemchandra Bora, and Jyotin and Tarini Bora muted. So in tag number, their name is there. And after 27, as per note C, a mention in the Jamabandi is corrected as per order of circle officer. Name of the Hemkanta Bora muted by gift in respect of land of 1 kata 7 lesser of land in Dag number 772. One biggest point, these are all are gifted by other is 10 in the, which is after correction of the Jamabandi. In para 28, oral evidence shows that there is an amicable settlement partition took place among the legal heirs of the Patichandra Bora, and Patichandra Bora distributed his property during his lifetime among all children. The Jamabundi copy exhibited by both the parties pointed that Food Patta land is distributed among 4 sons of late Patichandra Bora, and as per distribution of that number 782 fell in the share of the plaintiff and defendant. The properties of the suit and other legal heirs have not disputed their mutation. So when this so far suit land is concerned, other still brothers and sisters are not have never disputed regarding their mutation. The question of gender of the and non-gender of the necessary party does not arise. They are not raising any objection. In respect of the other land of the suit patta in the Jamabandi, they have gone for the Jamabandi in which part that number and who was muted against which brother and sister. They never raised restriction, they never had challenge also. So even if the appellant house is not challenge, the house in Tarikan Para's name is entered in the number 782. Jamabandi. When I am telling he is not entitled to the half share, then it is my duty to challenge the Jamabandi copy. It is wrong. They prudently made. There is a mistake. He is not telling. Now he says his father is on the basis of keep.
But Jamabandi had his name also.
His name also. Both the brothers' name is there.
Question of challenging why that is not causing any problem.
That's my matter. If my name is there, my brother's name there, when I am entitled, my brother also entitled. This is father's property.
Yes.
It is not my self-record property that I will not give to my brother. It is my father's property. It is a law of inheritance as per Hindu law. He is entitled for brother's property.
In this particular suit land, in the Jamabandi, names of the other brothers were not appearing.
They are only Hemchandra Bora and
Plaintiff and the defendant.
yes, appellant and defendant. On their name is there. And if it is corrected by the circle officer, if it is not in record, so it is not telling as a prudent, Tanikanth Bora's name should not be there. It should be in my name only. Then automatically
Presently, what is the situation? How much is this area of this particular Jamabandi?
there are only two bigger 12 places. Under that number 782.
You are in possession of how much?
I am not in possession. I filed this title suit for my declaration of my title over this land and recovery of the possession. But
did you file for recovery also?
Recovery of the possession also.
No, where is the we have gone through the.
I am not recover. I could not recover.
No, where is
Separate position of it.
Separate possession.
Not recovery of position.
Recovery of the possession.
No, I think Mr. Sundi had read out the relief. There's no recovery of possession.
No, my lord, here he is in my title for.
Let us see the plaint. Have you said that you are dispossessed?
No, my lord. I was not allowed to enter in this premises, my lord. But I could have filed after getting this appellate order, my lord, I could have filed execution case. But in the meantime, they approached to the honorable court and obtained this stay order.
That is a different, but where is the
different.
execution of
Yes,
decree
but-
for recovery of position?
A suit for declaration of the plaintiff half share in the suit land, building with a partition and separate possession of his share and permanent injunction. He is seeking his separate possession in the same suit land. I am seeking the possession. Since I am seeking the possession, I am entitled as per Jamabundi, which is not
We may not
entitled.
be able to complete today, what
Ma'am.
to do? We fixed another date.
They may be kept as a part of my.
Not part of the, have you made any statement in the plaint that this particular property is presently in the possession of the defendant?
No, it is not in my possession, my lord.
No, have you stated that the
Yes,
property,
my lord, I have issued the.
where
plaint.
have you stated in the plaint?
Yes, my lord, in my plaint. In my,
Okay, we'll have to fix.
in my title suit, my
Madam,
lord.
we'll have to fix another date.
Yes, my lord.
Sorry, could not finish anything.
Next week,
Suit of the 15
my lord, date is
Next,
next Friday.
Next Friday, next Thursday is
Next 35 to.
already we have fixed many matters.
My lord, of course, not it.
15 matter, 9-year-old.
My lord, as the lordship please.
No, paucity of time did not permit the matter to be taken up today. Full stop. Considering that the appeal is of the year 2015, raised to list it for hearing. It's for hearing today
Yes, my lord.
expeditiously. On an early date. We'll not fix a date.
My lord, date may fix, my lord.
Huh?
The date will be complete.
2015 matter, it will
My
come.
Yes, my lord, date may fix, my lord.
On a date in the first week, immediately on the reopening of
My-
the summer vacation.
Part of the item 22 and 20. These matters may also come in the part-heard matter, but
22, 23, what were those matters?
22, 22 item I have, Mr. Reddy Chaudhary was there, and 23. He is the appellant and I have got the respondent. Item 22, lordship, Mr. M.U. Mahmood is there again.
We wanted to make part heard, madam.
Already heard this matter, Mohammad Haider Ali, lordship, I am arguing on the point of, without filing any cross objection, he can challenge the entire judge. On that point, your lordship wanted to hear some.
Difficult to make part heard. If we are in a bench, same bench, then you can mention and we can take up the matter. If there is a change in bench, would not like to take.
Then it may be remained as leftover, lordship will mention if your lordship is sitting the next
Yes, yes.
25th, there
If
is.
we are continuing this bench,
Lordship.
make a mention.
Lordship.
Or we can have it listed in the on Wednesday next.
Lordship, any date.
Oh.
20 is a Thursday and
We'll have it on Wednesday.
Lord.
Both the matters. Huh?
Lord.
If this bench is there, you can make a
19th,
mention.
Lord.
Huh? On 19th, huh? On request list on so and so, 19th.
And
Okay.
lordship, item 6 and 21 is there, lordship has not started, but only to fix a date.
We'll give a date.
Lordship, obliged.